So he really wanted the case. And I know the owner of the firm was very hesitant. And we were all in a conference room at a table. And he was kind of asking us, well, how much revenue do you make? And we were telling him, well, 70,000. And he was saying, oh man, you make 70,000 a month? Like this lawsuit is going to be way more expensive than that. And we had to tell him, well, it's actually more like 70,000 per year.
Welcome to the TRXL podcast. I'm Evan TRXL, and in this episode, I welcome Garrett Reynolds. Garrett is the co-founder and president of UpCodes, the company that puts building codes online for free and made them searchable. He started a PhD in machine learning at UCLA, dropped out to join PlanGrid's machine learning team, and in 2016, he teamed up with his brother Scott, who was an architect, to build UpCodes out of their kitchen. What started as a simple idea, put the codes online and make them control-F-able, turned into something neither of them planned on, a decade of litigation against the organizations that published those codes. Garrett's brother Scott has been on the show before a few times to talk about the fight. This time, Garrett gives the update, and there is a lot of it. UpCodes has been sued repeatedly since 2017 by the International Code Council, by ASTM, by the Facilities Guidelines Institute, over copyright, trademark, even for using the letters ASTM on their own website. They've won every case so far, and along the way helped establish, alongside a parallel Supreme Court case, that no one can own the law. Having lost in court, the code publishers have turned to Congress with the so-called Pro-Codes Act, a bill named to sound like the opposite of what it actually does. Today we get into how the litigation actually works, why running out of money can be a reason a lawyer won't take your case, what it's like getting served lawsuits on your apartment doorstep, and why the code's publishers keep setting revenue records even while claiming they're being driven out of business. Garrett also breaks down the legislative fight, how a bill gets fast-tracked through Congress under a process meant for renaming post offices, and how a small number of constituent emails can be enough to get a staffer's attention on a bill nobody's supposed to be watching. What strikes me is how much of this fight has nothing to do with technology or progress and everything to do with money, lobbying, and legal endurance. UpCodes didn't win by building a better product, though they did that too. They won by finding a way to keep paying for lawyers long enough for the law to catch up with them. That's a strange thing to say about access to the building codes, but it's where we are. As usual, there's an extensive amount of additional information in the show notes, so please be sure to check that out. You can find them directly in your podcast app if you're a paid supporter of TRXL Plus. And I would like to thank all of you supporting members right now for your continued support. It means a lot to me. And if you're a free member, you can find the show notes and more about becoming a supporting member over at TRXL.co. So without further ado, I bring you my conversation with Garrett Reynolds. Garrett, welcome to the podcast. Great to have you on the podcast to provide an update to what's going on in the world of copywriting the law or owning the law. I mean, you have a few different amazing taglines that you guys have put into the lexicon of us architects who should care about such things. So, okay, we have some catching up to do, and but first, welcome to the show. Great to have you. And
thanks for having me.
Yeah, and your brother's been on the show a few times in the past, maybe even 4 times, I think. And first appearance from you, the other half of the co-founder of UpCodes, right? Is that how it worked? Both of you are the co-founders.
Yes, we are. Yep.
And what's that like, brother and brother co-founding a business? You guys just fight a lot, I bet.
It's actually been great. Our parents were a little bit worried when we started the company over 10 years ago. But it's been really good. It's nice having someone you can trust. And we actually have a great relationship. And we also kind of have different areas of strengths and weaknesses.
Yeah.
So we kind of complement each other well.
Nice. I'm sure we'll get into that in this conversation as well, because your career has changed. I hate to say it like that. It's not what you planned on doing. So anyway, let's do an update from the last time Scott was on, because I think almost every time he's been on the podcast, it's really been to talk about kind of the latest version of the issues of copywriting the law and that you are dealing with. And you're like, I think one of the previous episode titles was Fighting the Good Fight. And you guys have definitely continued to hold that banner. So catch us up on where things have been in the last couple of years with the Pro-Codes Act, which is kind of a maybe potentially subversively named thing in legislation, and the ICC and copywriting building codes and all those kinds of things.
Sure. And just to maybe give a quick kind of background to anyone who's not familiar with the cases, so we've been litigating against these code publishers going back all the way to 2017. So that was August 2017, the first case being brought by the International Code Council against us. And we have been fighting lawsuits ever since. So, they've been going well. So in 2020, actually, a separate case from ours actually went to the Supreme Court, where the Supreme Court said, quote, "No one can own the law." Our case, the judge had actually been waiting on the Supreme Court to rule. And once the Supreme Court ruled, our judge ruled similarly, saying if the ICOs are adopted into law, they cannot be copyrighted, and you cannot use copyright to restrict the dissemination of that law.
Mm-hmm.
And so we had that ruling. That was 2020. ICC brought a second lawsuit very soon after that. I think it was 9 days after. So they brought a lawsuit for false advertising and unfair competition. Now, the most recent lawsuit they brought was 2023. So another lawsuit. This one focused on copyright management information, which is basically the copyright notice. So essentially suing us for not having posted the copyright notice along with the law.
Mm-hmm.
And then in the meantime, we've had some other cases too. We had a case with Facility Guidelines Institute, who has the regulations that govern hospitals. And then most recently, ASTM sued us in 2024. So that's kind of the background or the high-level facts of the litigation. And so far, it's gone well. No court has ever ordered us to remove access to the law. And having failed in the courts, the publishers have now turned to Congress. They're pushing a bill called the ProCodes Act. Sounds like a good name, but in reality, it is a bill that aims to give them copyright ownership over the law itself. Basically, what they wanted in the courts, they couldn't get from the courts. They have now turned to Congress. They have been spending millions of dollars lobbying Congress. And that's where we are now. Now we're, fighting in the legislature against this bill that is really targeting us.
Yeah. And so, okay, before we get on with this conversation, I think it would be cool to ground this back to practice and like a firm's architectural practice, engineering practice, but also their tech stack. I think that would probably help relate this to the audience for this podcast. So if the ProCodes Act or some version of that approach were to win, what breaks inside of a modern firm's tech stack and practice?
So the aim of the publishers is to get that copyright on the law. And let's suppose they achieved their aim, whether through the courts or some other method. If they could do that, then they would become the sole gatekeepers of the law. So we're talking about building codes, mechanical codes, accessibility codes, elevator codes, all these codes that your audience will know well. If they get that copyright, they may give some kind of limited free access to see the law, but they would have all kinds of restrictions. And, the courts have commented on these restrictions before. Some of the reading rooms, for example, I think in the ASTM case that also involved ASHRAE, one of the publishers, the judge noted, okay, you have the reading room, but the font's too small to read. I have to pay to get bigger font.
So can you explain what a reading room is real quick? Just is it an actual physical location where these volumes are stored that people can then go to and check them out and look at them? Or is there a digital version of that? What does that actually mean?
Yeah, good question. So it can be both actually. So in the court cases, some publishers have pointed at physical reading, like the ability to physically read the code. So they will say, this company over here or this organization doesn't need to give the law away for free because we already give the law for free. You can go find it in your state capitol and you can inspect the book in the Capitol building. Now, some of the publishers, especially since UpCodes came on the scene and started giving free access to the law, have set up virtual reading rooms, as they call them. And these are places where you can see the law, but it's heavily restricted. So, for example, you can't copy paste the law, which I think a lot of your listeners may have been on some of the publisher sites before. You'll notice on almost none of them can you actually copy paste the text of the codes. You can't print the codes, but most importantly, you can't quote the codes without their permission. So if you look at their terms, and you are forced to enter into their terms if you want access to the codes, their terms will say you agree not to redistribute any portion, no matter how big or small, of this without our express permission. Well, that means if you want to quote, say, 2 sentences from the code, you technically have to go get their permission or you are breaching their contract. And so it kind of like the goal is to remove people's ability to speak the law. Just looking at the law is not sufficient. The citizens need to be able to speak the words of the law. They need to be able to share the law, copy paste the law, criticize the law. It's not enough that you can just look at it. Even if they weren't playing all the games with the reading rooms, where it's like, like I mentioned, the font's too small, or another judge noted that it was very hard to find the reading room, but the books for sale were very easy to find.
Yeah.
And but even if they were providing true access to look at the law, it's still insufficient.
Can you explain why the lawsuit started and why now the legislation is trying to be, I mean, obviously they're trying to limit, it seems to me, and so I want to get the real story from you, but it seems to me like they want to be the sole distributor of this information. But I think it's important in your explanation that you explain where that information originated from as well.
Right, exactly. So the codes, if people aren't familiar, are written by volunteers. The analogy we like to use is it's like a scientific publisher where the scientist will create the work. You might have a peer review to review it. And then at the end of the day, the scientific publisher registers a copyright on it and claims ownership over it. So you have a similar model here, just that instead of a science paper, which you can choose to read, it is actually the law. If you do not follow it, if you choose to intentionally disobey it, you will face penalties, civil or criminal.
Yeah.
But yes, it starts with the volunteers who write the codes. That includes
who are explain who these people are who are actually participating in that process, because what you're not talking about is like a crowdsourcing exercise, right? We're talking about professionals, and this is something that they have volunteered to do, and they participate in what I would assume is a pretty arduous process to amend the code over the years through each code cycle.
Right. It is a lot of work. The volunteers are made of industry professionals, interested third parties, so that might be manufacturers, and also government officials. So you actually have a large number of government officials who use their time to work on the next edition of the codes. So those different interest groups come together to author the next edition of the codes. And now the publishers do a good work of organizing the volunteers who are writing the codes, and that's not nothing. But at the end of the day, the codes are written by volunteers who are never compensated for that.
So is that true for all of those different interest groups? So I mean, well, obviously there's like the industry professionals who are volunteering, and volunteer is the key word there, right? I mean, so that to me says unpaid. But then you also mentioned like some government entities and people who work for different governments. Are they is it on that time, or is it a completely separate thing from their normal job?
From what I've heard, the government officials are the only ones. I guess you could say they are compensated. They're not compensated by the
directly
publishers
for that. Oh, okay. Yeah.
And the publishers do make a lot of money off these codes. So that money never goes to the people writing the codes, but the government officials are typically on the clock when they are helping to write the codes. So that is part of their job.
Yeah. So these do generate revenue, right? So and that's also kind of the linchpin, I think, for the argument, right? So can you talk about that side of it? I think, professionals who've been working with building codes in over the decades know that there's physical copies of code books in lots of offices and lots of studios, and these are big volumes with lots of paper in them traditionally, and now that's moved more digitally. But can you just talk about kind of that revenue model and how that currently works?
Sure. Yeah. So, a lot of organizations are now giving the law for free. And so a lot of the revenues that the publishers are seeing, and the publishers are seeing increasing revenues actually, uh, is coming from all the auxiliary services. So consulting, inspection, testing, certification, training materials. So the fact that the
Mm.
publisher basically sets what the law is, endows all their other services with a lot of value.
Mm.
And they've been able to increase their revenues year over year. So if you look at the International Code Council, for example, uh, their codes have been posted by UpCodes, by Public Resource Org. That is their codes that were adopted into law. Some of their codes are not adopted, and we obviously don't host those. But their codes have been posted by us for over 10 years, yet they set new record revenues every single year since we started.
This episode of the TRXL podcast is supported by Avail, and I wanted to share a piece of a conversation I recently had with one of Avail's customers. Check it out. What was the moment or the project that finally made your firm say, we actually need to manage this stuff? Do you remember?
I was there. We actually came from another platform. And so it was a platform that we felt like wasn't sort of really invested in the customer and wasn't really sort of understanding the customer's problems. They sort of had a much harder to navigate user interface. It made it harder to sort of upload and harvest these projects in the method that we wanted. And so we looked at a bunch of different products when we were abandoning that previous platform. We met Randall and his team, and we felt that these guys understand us. And so we went with their platform a number of years ago, and the community and the support that they've provided has kept us, lockstep with their advancements and development. And we just got a preview, I think, last month on some of the stuff that they're going to release this year, and couldn't be more excited. It's always something that I knew I wanted but couldn't quite articulate, and Randall always is able to do that for us. So this next roadmap is super exciting.
My thanks to Avail for supporting this episode of the TRXL podcast. Now let's get back to the conversation. So like the probably the common thinking would be, since you guys have come along, you're eating away at their revenue model, right? Their business model of selling books and access to the codes. But the opposite is what you're saying has actually happened. Since you have been posting for the last 10 years, it's also sent more people to these auxiliary revenue channels potentially, right? Like maybe not directly, but or maybe directly, maybe indirectly. But you're saying that because I believe isn't there, because they're a nonprofit, right? So they actually have to make public these kinds of records so you can actually see exactly what the revenues that they're generating are year after year.
Exactly, yeah. So they make their revenues public in the IRS Form 990. And if you just search International Code Council 990, you will find that form online.
Okay.
And yes, so they report that publicly. You can see the revenue going up. You can see the pay of the executives, which is very, very high for a nonprofit. In fact, the CEO's salary is north of $1,400,000 per year for this ICC, which is more than 10 times the median salary of a nonprofit CEO. So, they might not be able to rely as much on, paywalling the actual law and selling access to the law as they could have, say 30 years ago before all these cases started landing. And I should say, these cases were already starting to land before UpCodes even came on the scene. So back in 2002, there was a seminal case in the Fifth Circuit, which is, comprises Texas and some other states. In that case, you had SBCCI, which went on to become ICC, suing someone for posting the building code. And they lost. And that was kind of the case
Who's
that really...
they?
SBCCI lost.
Okay. Mm-hmm.
And the person, it was just one individual named Peter Veck. He was posting the code of his town. And
why?
The court...
Just to make it easy for other professionals to access it?
Yeah. As far as I know, he just set up a little website, put the code on there for his town.
He's not claiming he's the author of it, right?
Right. No, he's saying here's the building code of Anna, Texas.
Okay.
And they went after him right away. And they were kind of unlucky. Usually I think what the play is you sue someone. If they don't have money to defend themselves, then they're wrong. And unfortunately for ICC's predecessor, this particular individual inherited quite a lot of money from his parents, and he just fought it out of principle, basically.
Wow.
Yeah, and if not for him, UpCodes certainly wouldn't be here today. So that was the case.
Okay.
Yeah. But after that, I think the publishers kind of started realizing, okay, we're not going to be able to sell access to the law forever. The courts are not upholding our copyrights over the law itself. And the
copyrights had been issued, right? Like, that's what's interesting, right? I mean, can you talk about, I think it would be good to just mention the difference between trademarks and copyrights, because you know more about this than I do. And there are differences between those, but also that there was one issued against this volume of work that then, like you're saying, now they can bring a lawsuit because somebody violated the copyright by posting that information. And this it also plays into this whole idea of controlling access to the law or owning the law. There's different levels, I think.
Right, exactly. And copyright is very different than patent or trademarks. So if you want a patent or you want a trademark, you have to apply for it. And it takes months, and you have to submit documentation, and you might have to argue why you should have it. Other people get a chance to challenge it before you get it. So it can be challenged by other parties who maybe think that that's not a valid patent or trademark. Copyright is very different. In copyright, you are presumed to have a copyright as soon as you write something. And you can register a copyright, and it costs about, I think it's either $20 or $50. You register it with the Copyright Office, and no one checks it. You just add it to the database. No one ever looks at it.
Okay.
So they register copyright on these codes. What people don't realize is all that is paying $50 and sending a form that no one reads. Now,
and then every new version gets that. Basically, they do that again, that process over and over. So, I mean, that's kind of a little bit of foreshadowing, I think, just that there's a new version every few years, and we'll get to that. Something happens every few years now.
Right, exactly. So they will register a copyright each, code cycle, which is typically 3 years. And but at the end of the day, you can register a copyright on anything. For example, I could register a copyright on something I probably shouldn't have a copyright on, and it'll be registered. But when I go to challenge someone on it in a court, I would just lose the case because the court would not uphold my copyright.
But copyrights also protect, like, the instruments of service of an architectural firm when it comes to contract documents, right? So your plans copyrighted, right? Specs copyrighted, like the book, so all of those kinds of things are. So I think the audience is pretty familiar with copyright, but they're a little different than some of the other, trademarks and patents, like you said.
Right, exactly. So the output of a firm, like plans they make, will be assumed to be copyrighted by the firm. Some employee can't just copy all the drawings and then start selling them after he leaves the firm, he or she.
Or someone else can't build another building off that set of plans, et cetera.
Right.
Yeah.
Right. Yeah. So, I mean, copyright plays a really important role in the industry overall. Obviously, legitimate copyrights need to be upheld. It's just that the system gets a little bit abused sometimes, as we've kind of seen in various cases.
Hmm. Okay. So I forget where we were going with that, but I do want to talk about, just talked about these lawsuits, and I would love to just kind of hear the story. So we'll cue the nostalgic music here for you, Garrett, but like take us back to what it was like when you got that first lawsuit, and kind of talk about even the timeline that's happened since then. Like you said, then after that one, you went to court. Then 9 days later, you get served with another one. I mean, this has just kind of been a nonstop saga for something that you never planned for. And so, like, what was that like, just getting served those papers originally?
It was scary. We had started the company in February 2016. We did it for about a year and a half. No one bothered us, and we actually thought we were safe. We were posting the ICC codes. We said, well, they litigated this and lost as their predecessor, SBCCI. So it was our understanding they couldn't litigate again. Now that was, we learned better later, but we the summer in the second year, and so that was 2017. We still hadn't paid ourselves anything. So Scott had moved out to San Francisco. He was living in my studio apartment in an airbed for the first, I think, 2+ years. And, we were working out of our kitchen and just kind of using our savings to build the company, pay for the servers.
And can you just talk about like what your original idea and business model were back then?
Yeah, our original idea was let's put these codes online and make them searchable. That was it. Scott was working at an architecture firm. I got to go into the architecture firm, see the actual books. I saw that they would staple the amendments into the books, staple the updates, or, a binder, and they're slipping pages into the binder.
Yep, that's what we had. 3-ring binder, really big ones, and like 6 inches thick, right? And we're doing public work, and so lots of different, and then one for every 3 years because we had projects in different code cycles, and they get locked into those code cycles. So you need to be able to go back and refer to that code cycle. But then there's the white sheets, and then there were the green sheets, and the green sheets were all the amendments, the updates that came out throughout that code cycle for things that needed to be addressed inside the code itself. But yeah, I mean, this was kind of standard office fare, 90s, early 2000s. What year are you're taking us back here to, what did you say?
That was 2015, around November. Yeah, I came out to New York City. He was working as an architect at KPF, and I got to go in over Thanksgiving actually because the office was closed. So he gave me a little tour of his office, and he had this idea. He was saying we need to put these online.
What if we could Control F this document, right? Like that. That's kind of an innovative idea, even though now it just sounds absurd, right? Because everything's online, right? But back then, if you needed to find something in that giant volume of information, you either needed to know where to look, you needed to ask somebody where to look, et cetera, et cetera. It was, or you had to figure it out on your own, right? So, not the easiest thing, and just like access was there, but it was difficult, especially for like a junior architect back in the day. What does this mean? What are these exemptions? What are refer to this other section. I can't even find this other section. How would I even know to look for the stuff like that? So you can see that there's plenty of opportunities to innovate on top of this old model.
Right. And even in 2015, it was kind of surprising. I mean, how are these codes still only available in the books? And why are you stapling amendments into the books? It's 21st century. What's going on here? And we thought we had come up with this great idea that no one else had thought of. And turns out a lot of people had actually thought of this very same idea. We learned later, and we also learned why no one else was doing it and why it was kind of anyone trying to do it was kind of being crushed. But we said, okay, let's put this online. So we did. Put the codes online. We started with New York City Building Code, I think was our first one. And we launched the website on February 2016. Scott quit his job, moved into my studio. I was still working actually, and then kind of moonlighting on UpCodes, but I was working so that we could share a salary. So he would work on UpCodes full time. I was going to work and then working on UpCodes at the nights and weekends.
Hmm.
and splitting my salary with him. And yeah, it just kind of grew from there.
But that wasn't the business model, wasn't just to post them online. What was your original idea to, because it doesn't sound like you wanted to charge people to access the online version of this, but you tell me.
Right. I mean, our idea was, I mean, I don't even know if we discussed, I mean, in the first almost year of UpCodes, you couldn't even pay us any. There was nothing to pay for.
Hmm.
We were just putting the codes online and making them searchable.
Okay.
We didn't really have like a fully fleshed out plan.
Uh-huh.
We just thought we should do this. It'll be cool. And like, it's obviously very needed. We'll
Like as a service to the industry, is that what you're thinking? Like the people,
yeah,
people
I mean,
could really use a searchable version of this.
right. Yeah. People could use it. It'll be a fun project. Yeah, we can do it. We might as well. Maybe we'll do a business with it. We'll see.
Hmm.
And yeah, I think about many months later, we were saying, okay, we do have server costs. Like this is actually growing. People are coming on our site. We need to make money. We also like, if we want to go full time, I was still working at PlanGrid actually. We need to be able to make some money here. So
And this is just spreading word of mouth kind of thing.
exactly.
I mean,
Yep.
you have a public facing website, but people don't just find public facing websites unless they're searching for them or hear about them, right? So it's,
Yeah, we had also a lot of SEO, search engine optimization. It means inbound from Google.
yeah.
And the reason for that is we were the only place to see the codes for free at the time.
Mm.
Now, ICC has a free restricted reading room, but at the time, you kind of had to come to UpCodes if you wanted to look at, you want to look at chapter 1 of the New York City was an exception. They did post their code, but say New York State building code, you'd come to UpCodes. So we did get that. Also, word of mouth was pretty big for us. And yeah, we kind of grew it from there. We added a paid tier. So I was like, advanced search, collaboration tools for your team, so commenting projects. And then we got into the Y Combinator program, which is a incubator. They kind of invest in you and help you grow. And it was around August where we were raising our first round, and we had learned more. We had kind of boned up more on the legal side, and we thought that it's possible we could get sued. I mean, we were also planning on posting more codes, and even though there was so much case law already saying you can't own the law and you can't restrict the law, we had heard like certain organizations were very litigious. We were planning on posting more codes. We were not expecting ICC to sue us, but they did. And basically what that looked like was we were in South Bay in the Bay Area raising. I mean, we spent like maybe 4 weeks just working 7 days a week from, waking up to going to bed. And we were completely exhausted, and we were going to take a couple days off just to recharge. We took the train back up to San Francisco to my studio. And when we got to the apartment, there was a serve on the doorstep of our apartment. And it was about 100 pages. It was a court summons from ICC. And it was we just kind of freaked out. We were planning to take it easy, but
Right.
instead we just, got hit with this really intense serve.
And the goal a lot of times for that kind of thing is just to try to overwhelm the other party, right? Like I could imagine that feeling that you're describing just being completely overwhelming and kind of like getting punched in the gut.
Exactly. And every case we've had, including this first one when we got back to the apartment, has been against the company, UpCodes, but also me and my brother personally. So they don't just go after the company, they're going after your personal finances. And I mean, we were talking to lawyers and saying, what is it that they're seeking? And they said, well, they're seeking $6 million of damages. And we said, well, we think we're going to win. It's like, according to the case law, we should win, but, nothing's 100% certain.
Mm-hmm.
And so we were asking them, what does that look like? And they were saying, well, you would be personally responsible for that. And furthermore, copyright debts cannot be expunged with personal bankruptcy. So those debts will follow you around for the rest of your life if the ICC were to get what it wanted. So yeah, they definitely put the maximum pressure on you personally. They're trying to basically make it like so overwhelming that you just go to them and you say, okay, what do you want?
Just beg. Yeah.
Yeah. And we were, at the time we were making, I think our revenue was small, and we went to get a litigation firm. We said, okay, we got to fight this. This is wrong. And we got to beat these guys at all costs. So we found a litigation firm. They were very hesitant to take us. The reason being the owner was worried that we would run out of money. And in the US, if one of the parties runs out of money, especially the defendant, the lawyer may have to continue representing them, even if they're not being paid. So the lawyer will go to the court and say, my client's not paying me. Will you let me off the hook? And sometimes the court will say, no, you have to keep going.
Interesting.
Yeah. So that's
so they were concerned that you might put them in that situation. And so
yes,
therefore
exactly.
They don't even want to get in that situation. Yeah. Okay.
Yeah. And we were sitting in a room. One of the litigators, he really wanted the case, Joe Gratz, and because it's a very prestigious case within copyright defense, it is like, can you copyright the law? It's not just some.
It's got a nice ring to it.
Dispute. Yeah, exactly.
Could put that on the LinkedIn profile.
Yeah. So he really wanted the case, and I know the owner of the firm was very hesitant, and we were all at a conference room. In a conference room at a table, and he was kind of asking us, well, how much revenue do you make? And we were telling him, well, 70,000. And he was saying, oh man, you make 70,000 a month? Like, this lawsuit is going to be way more expensive than that. And we had to tell him, well, it's actually more like 70,000 per year.
More like,
so
yeah.
He was just not.
It's
having...
a 12th. It's a 12th of the number. Yeah. So that's kind of crazy, right? That a lawyer would even say, "Oh, your revenues." You guys are, you're young, right? And it's like 70,000 a month is not enough to pay for this lawsuit. That's just kind of crazy. Just taking a step back and just looking at the construct that we operate in, like that just is kind of mind blowing.
Yes. And that's the basis of lawfare in the US. And the US is special because the US has something called American rule versus British rule. So in British rule, the prevailing party has their attorney's fees paid by the other side. And what that means is if you are, say, defending yourself and you're very likely to win the lawsuit, an attorney might just take the case and say, well, once we get paid the attorney fees, I'm going to get paid.
Right.
But in the US, the prevailing party does not have to pay the attorney fees of the party who loses does not have to pay the attorney fees of the other side. And so what happens a lot is big incumbents will sue startups, just bury them in legal costs, and then go for a settlement. And we've had, over the years, we've had like multiple people reach out to us saying, hey, this is really cool what you do. I tried to do the same exact thing, but I just got completely shut down. And how are you guys doing it? And we kind of realized over time, the main innovation of UpCodes in the early days for the first few years was to find a way to sustainably fight back against the publishers. And that was a mix of making enough revenue from the users to pay for the lawsuit. And for the first couple of years, basically 100% of our revenue went to the publisher. The litigation team.
You didn't plan on that in your business model.
No, not at all.
Oh, man.
Yeah. And so that was kind of our, And so putting all the codes online, making them searchable is not that hard technically. But the hard part was fighting the lawsuits.
Yeah.
And that was the part that we kind of cracked, basically.
Let's take a short break from the conversation to invite you to join the most influential technology leaders in the AEC industry at Confluence. Composed of in-person events and a podcast co-hosted by yours truly, Confluence is designed to foster conversations between AEC firms and technology companies so they can learn, share, and engage with each other to support industry innovation. Software company Avail, which creates content management solutions for the AEC industry, started hosting Confluence events in 2019 to understand what firms are needing, wanting, and thinking around technology. To learn more about Confluence, explore upcoming events, and listen to podcast episodes, go to confluence.getavail.com. My thanks to Confluence for supporting this episode of the TRXL podcast. And now, let's get back to the conversation. Okay, so talk about like that early win and what that did for your morale, but also maybe, you thought it was, I think you said earlier, you thought it was kind of over at that point.
Yeah, I mean, so the first couple of years was a lot of struggle on the financial side. As soon as we got the lawsuit, I think we kind of internally made a conservative projection of what our cash would look like, a moderate projection, and then an optimistic projection. All three projections just went straight down into the x-axis. So we knew we had to raise more money. And fortunately, we were able to raise more in 2018. And that's when all the depositions were, which is when you basically get interrogated. And then, so basically we had this parallel case going on. It was going to the Supreme Court. This was Georgia versus Public Resource Org. And our Judge Marrero, clearly decided to wait to see what the Supreme Court would do with that case.
Okay.
Now, it wasn't an identical case to the one we were dealing with, but it was very similar.
Yeah, talk about just like a overall summary of what that case was.
That case was about annotations to the Georgia Building Code. The Georgia Building Code being based off the IBC. So what happened was the Georgia government contracted LexisNexis to create essentially like a code commentary.
Mm-hmm.
And the case was not about whether you could copyright the Georgia Building Code, which was the law, but whether you could copyright the commentary on top of it.
And what's the purpose of the commentary? Just the explainer kind of stuff that sits in the column on the side of the page?
Exactly, yeah. So it's annotations that explain things, helped you understand what different terms meant, and created by LexisNexis. And it was a very close decision in the Supreme Court when it got there, but in a 5-4 decision, that was actually split. It was interestingly split by age. So the 5 youngest judges went in favor of public resource, and the 4 older judges went for the copyright holder, went for basically LexisNexis. But the court ruled that no, these commentaries, they were created by LexisNexis, but LexisNexis was working as an agent of the government because they were contracted and paid by the government. And so for that reason, the annotations cannot be copyrighted. Those are public domain. Now, what they parenthetically said was, of course, though, the underlying law, everyone agreed, even though it was a close decision, 5-4, everyone agreed that the underlying law is not copyrightable. So you have, if I can pull this up, there were some great quotes from that case, actually. So Justice Thomas said, statutes and regulations cannot be copyrighted. Justice Roberts said, no one can own the law. And Justice Ginsburg said, beyond doubt, state laws are not copyrightable. So we thought, great. So are we done? And lo and behold, our lawyers told us, no, not quite. You still need to see out the lawsuits, and it wasn't an identical case, so you can't just dismiss your lawsuits. So we went back to fighting. Now, very soon after the Supreme Court ruled, our judge then came in, and he said he ruled in our favor. And it was a very strong ruling because he said the UpCodes as adopted are in the public domain. But even if a superior court were to strike that ruling down, I'm also ruling that these are fair use to post these laws.
I was going to ask about fair use. Yeah.
Yeah, which is a copyright defense. And then he said, even if they were to also strike down fair use, I'm also ruling that it's fine for UpCodes to post these based on another defense called merger doctrine. And so we kind of like won 3 different ways, which is
What
really
does that
nice.
mean? What's merger doctrine?
Merger doctrine says if there's only one or a few ways of expressing something, then it cannot be copyrighted. So for example, let's say I write down 17 plus 4 equals 21. I cannot copyright that because there's only one way, or maybe, a couple ways of expressing the idea of that addition. And so that's fortunately why people can't copyright math. But, in this case, the judge said, there is only one way to say the law. Like UpCodes cannot paraphrase the law. That's not sufficient. It's not reasonable. If UpCodes was paraphrasing the law, you couldn't use that. You need the exact text of the law.
I mean, that also kind of leads back to that LexisNexis and the comments, right? It's like, I mean, you're not paraphrasing the law, but it is living next to it to kind of interpret and explain or to provide a glossary or additional information. It's just interesting that like these things get so dialed in, and it's like there's so much gray area. There's a lot of blurriness to all of this in the definitions and things like that.
Right, exactly. I mean, and the other side was also arguing like, oh, but UpCodes posted some non-mandatory information. For example, information that, say, clarified definitions. But that wasn't, they were saying these aren't rules. Like, they were saying this is different than a sentence that says your handrail must be X inches off the ground. They're saying this is just a kind of clarifying information. They shouldn't have posted that. And they should have kind of, we call it Swiss cheese law, where they wanted us to basically post just little pieces of the law. And our position was, well, look, the government adopted the whole book. So the whole book is the law. Now, having a clarification to a definition is important for the law. And essentially, like even stuff that maybe on the surface doesn't seem important could be relevant in some lawsuit. If some builder is being sued by the developer or by the occupant, it could be relevant, what this extra context says that is in the law. So we very much disagreed that we should only post portions of the code. And the court fortunately sided with us. So they kind of upheld our right to post things that went beyond just you shall do X, Y, Z.
Okay. So we're still early in the story here of the saga, because so the judge ruled in your favor at that one, and so you thought, okay, done.
We thought done. 9 days later, they filed kind of a Plan B lawsuit. It alleged false advertising and unfair competition. And they were upset with us, saying, "Hey, we're the only place where you can get the integrated codes." And they said, they pointed to, look, we have the California Building Code, and that has amendments integrated into it. And we were saying, okay, but California Building Code is published as a book. What we were talking about is like Alabama, Massachusetts, Louisiana, having the separate amendment stocks where we integrate it into the codes.
Okay.
And
so their fight here was with a claim that you make on your website.
Yeah, it was just suing us for marketing.
Okay.
And we immediately said, you know what, we don't agree with you. We don't think this is false advertising, because we do think we're the only place to find things like the Austin Building Code with the amendments integrated. However, just out of a sign of good faith, we'll just take down that marketing and say something else. Of course, they didn't really drop the lawsuit. That's not really the point of the lawsuit. We cured it immediately as soon as they notified us, even though we didn't really have to. But that lawsuit continued, and then they sued us again in 2023 with another copyright thing. That was copyright management information. So suing us for removing the copyright notice from the code, which is a totally separate claim.
Right.
And Yeah, in the meantime, FGI also sued us for copyright. So they sued us in 2022.
And FGI is?
Facility Guidelines Institute.
Okay.
Yeah. And then ASTM sued us in 2024 for copyright infringement alleged, and also trademark infringement too. ASTM, they kind of threw the book at us. They filed a preliminary injunction against us. So what that is, these court cases can take years to resolve, right?
Mm-hmm.
So as you can imagine, the plaintiff would like that the codes are down while the case is going on and while it's being decided.
Mm-hmm.
And UpCodes would like the codes to be available publicly while the case is being decided.
Mm-hmm.
And the preliminary injunction is just to decide which party gets its way while the case is going on.
Okay.
So they filed that against us. The courts kind of have a number of different factors they balance when they're looking at preliminary injunction. They may look at who's harmed more by a certain decision. But the way the court ruled was really nice, we thought. And the court basically ruled in favor of UpCodes, saying we're going to deny the preliminary injunction because ASTM is unlikely to succeed in this lawsuit. And so, that was great. It kind of tips the court's hand. It shows what the court's planning to do.
Yeah.
And so ASTM immediately appealed that to the circuit court, which is the, in the federal system, you go district court. So that'd be like Eastern District of Philadelphia, which is where they sued us. Then you go to the circuit court. So that would be the Third Circuit in this case. And then Supreme Court after that. So they appealed to the Third Circuit. We had the oral argument last year. And actually just in April, the Third Circuit ruled. And they ruled in our favor. They basically said, posting the law is fair use. Okay. And based on the fact that it's fair use, we're not going to deal with the other arguments because that's enough to dispose of the issue.
What did ASTM do at that point?
I guess so the circuit court rules, and then so that's done, but the district case continues on.
Wait. There was something about the ASTM one that was funky, right? It was that they didn't want you saying that it was ASTM?
Yes. So that was the trademark infringement allegation they made.
Okay, yeah. So explain that, because to me, this is just over the top crazy.
Yeah. So, to us too. So the base claim was, or sorry, not the base claim, but one of the claims was copyright infringement. You'd be more familiar with that. That's, hey, don't post the text of our codes, even if they're law.
Right.
Trademark was saying you shouldn't use the word ASTM on your website.
So ASTM is a trademarked acronym. Okay.
It is, yeah. So they say, don't use ASTM. We say, but, for example, New York City, or say Philadelphia adopts the ASTM A36. That's the only way to refer to what they adopt. And
you can't.
And that's how they refer to it.
You can't call it the A36. Like, what does that mean, right? You have no context for what that is. Right.
I mean, if I just said to someone, hey, do you have an A36? They would look at me like, what are you talking about?
Are you talking about airplanes? Are you talking about like the garbage disposal? Like, I don't know. I definitely don't think you're talking about a code section, right? I mean, It could be anything. It could be a Ferrari, right? It could be anything.
Exactly. And I mean, I think we even looked it up, and I think there was like a Samsung phone that's called the A36.
Okay.
So, and there's a lot of products called the A36.
And so that's so interesting, because it's like, that just seems really punitive or petty at that point, because it's like they literally are the source of the information and they don't want you to find them. Like that's why it just seems so petty, because it's like, don't use those 4 letters.
Right, exactly. And I mean, ASTM even appears in the text of the law. So what do they want us to do there?
And this is their own doing, right? Like, this is what they named it.
Yes, right, exactly. Yeah. And it is what everyone calls it. It's what the government. So the government will say, we adopt the A36 2022 or whatever version. That's how the government identifies the code. It's how the industry identifies the code. And it's how ASTM themselves identify their own codes.
So,
So
so there's plenty of precedent already there with the
yeah,
way that that information's identified, and so that seems like a no-brainer kind of a ruling to
exactly.
say,
Yeah. And
you know.
that's, I don't think that's like gone too far and so far. And
Hmm.
we're not too worried about that. But basically like in these lawsuits, they'll kind of throw the book at you. Um, and just, they're hoping something works. And if they can find a technicality that would make it very hard for you to post the law, then they'd be
Hmm.
happy with that.
Sure, sure.
Um, but yeah, that one's not too serious, I guess.
So, okay, so there's been these lawsuits over the years, and then the lawsuits weren't working. I mean, obviously, you're kind of creating precedents as you're going along. What happens? What's the new tactic?
Yeah, so the courts have not worked out in terms of trying to own the law. They have kind of unanimously upheld that no one can own the law. Um, and so the cases will continue. I mean, they're going to continue imposing litigation costs on us. We kind of expect them to keep doing that until a day.
It is now literally built into the business model
It is, yes,
because it has to be. I mean, that's
yes.
how businesses work, right?
Yeah, I mean, we kind of just assume as long as we're putting the law for free on our website, we're going to be getting harassed. And you even look last year, 41% of our total expenses was litigation.
But
And
I
so,
bet there are customers, clients on your side who are like, heck yeah, I don't mind helping pay for these bills because it actually matters to the practitioner in the end that you are doing this work on their behalf. I mean,
definitely. Yeah,
yeah.
we were very surprised in the early days. We had multiple times where we asked someone, they were a paid user, and we would user interview them to try to understand how they use the site. And we would talk to them, and they say, "Oh, I just look at the codes and I just kind of copy paste." And we were saying, "Well, do you use the search engine?" And they said, "No." We said, "Do you use the commenting?" And say, "No, I just copy paste, I print it." And we would say, "Oh, so why are you paying for the paid tier because you don't use any of the paid features?" And they would say, I'm just doing it to support you guys, and I want to help with the fight."
Wow. Yeah.
And that was really cool. We never expected that. We had that multiple times. I remember like, yeah, some of the folks who did that. So yeah, it was really important, and people really kind of, I think, appreciated us kind of bearing the brunt of this like
I mean, on
ferocious.
one level, yeah, I mean, you have to because they served you and you're involving you. But on the other hand, like you chose to fight it. You chose to, this is a battle worth fighting, right? I mean, even going
Exactly.
back to that Fifth Circuit, Texas, Peter saying, no, like I'm going to put my inheritance towards fighting this battle because thought it was the right thing to do.
Right, right. Yeah, it just felt, I mean, yeah, and in the beginning, I mean, it was so overwhelming. We were, there was a decision. Do we shut down the company? Because that was the only option out. And, you know, in the end, we just said it's just wrong, and we're just going to regret it for the rest of our lives if we don't like
Mm.
stand up to these guys.
Mm.
Um, yeah, we've been doing that for the last 8 years. Like I said, the cases continue, but you
We'll
were
talk
asking
about the
about,
legislation. Yeah, I'm
yeah,
curious about the new tactic because it even kind of has what I would call a misleading title.
yeah.
And
So
this is
the
Scott. Scott was on the podcast last to talk about this specifically, but things have updated. I mean, this was a couple of years ago at this point. So talk about the Pro Codes Act.
Yes, and there's been a lot of updates. So the full title of the bill is something like protecting and enhancing public access to the law, bill.
Sounds amazing. That
Yeah,
sounds
yeah.
perfect.
The only problem is that, as with many bills in DC, the bill does the opposite of how it's named. So the bill is all aimed at
It's
restricting
just
the law.
it's just like no need to look here. This is not the this this is
Exactly.
it's totally the opposite, like you said, of what it's actually trying to do.
Yeah, and it's gone through some iterations. So it was first introduced back in 2022. So I was in the 117th Congress. It failed, and when
So it didn't. So what does that mean when it fails? It didn't get enough support to even get voted on, or what does that mean?
yeah, in the 117th Congress. So each Congress is 2 years, and At the end of Congress, any bill that hasn't been signed into law by the president dies. And it all starts from fresh in the next Congress.
But that's an important point right there, right? Is that, oh, we can do it again. I mean,
yes,
2 years later.
Yes,
Okay.
and if you have millions of dollars to spend lobbying, you can do it as many times as you want.
Just keep spending the money. Okay.
Yeah. So 2022 was introduced, did not pass into law. It didn't really move at all. In the 118th Congress, it was introduced, and it was kind of pushed. ICC was in DC spending millions of dollars pushing it. And it was
so they're actually hiring professional lobbying groups to, and that's what you mean by pushing it. Like they're spending this money. Those lobbyists are connected. They're inside the system. They're shaking hands and kissing babies and doing all those kinds of things that is very political in nature, right? But it's very much to get things to happen. I mean, this is the way a lot of things happen in the legislature.
Exactly right. So DC is a bit of a revolving door. Someone will work in the government, and then they'll make a ton of great connections, and then they go work for a lobbying firm, and then they use those connections to influence the government policy. And when you have millions of dollars to spend, you can get some pretty heavy hitters. So, for example, the publishers on their side, they have Representative Lamar Smith, who is the chairman of the Judiciary Committee in the House for many years. So they have him as their lobbyist. And he goes and he's, best friends with all of these people
connected.
on the
Sure.
judiciary.
Yeah.
And he says, hey, can you do us a solid here?
Hey everyone, I want to take 30 seconds to talk about something that really matters to me. This podcast exists because I believe this industry deserves better conversations. No agenda, no corporate backing, just honest, in-depth dialogue with the people actually shaping where AEC is headed. More than 25,000 of you listen to this show, and less than 50 of you are direct supporters of what I'm doing. And I'm not saying that to make you feel guilty. I'm saying it because if this kind of independent media matters to you, if these conversations have ever changed how you think or introduced you to someone worth knowing, then the most direct way to keep it going is to become a TRXL Plus member. $12 a month, ad-free episodes, the full Leadership Edge newsletter with my deep dives and the things I don't say on the podcast, and the knowledge that you're one of the people making this possible. Head over to the website at trxl.co and click the join button. And either way, I'm really glad that you're here. Now let's get back to today's conversation. And also, I'm sure at some level presenting this as the Pro Codes Act. It is this, you believe in the building code, right? And you believe that we want to enhance and, do all these wonderful words that we used in the title of this law, right? To do the things. So I can imagine that, like there's the elevator pitch version of this, which is very short and it sounds super positive, and it's all based on even the name that they chose to name it.
Exactly. The bill has real appeal to people. It's not just, lobbyists kind of pushing it. It has real appeal. The publishers have been in DC many times. And I mean, they even have full-time staff, government relations staff who live there and just push this. And, they're going into Congress saying, okay, look, the courts are not upholding our copyrights on these codes. These are really important life safety regulations, which is true. And they're also very complex to write. And you really don't want the government writing these things. Like, you need industry professionals to write these codes, which is, great point. And they say, so if you don't want governments to start writing these codes and the taxpayers having to pay for that, then we need copyright protection or we're going to go out of business. And this is urgent. And this is an emergency, and we're going out of business right now.
But to your point, that's not the case at all. They're actually
totally
earning more and more than they've ever earned, and it's all based on these additional resources and things that they offer.
Right. It is totally the opposite of the truth. They're making more money than ever. They do not show the 990s to the offices. But that's what, they were pushing. And the offices did not realize that, in fact, they are not going out of business. They're making more money than ever. They're able to pay kind of outlandish executive salaries. And so, they pushed this bill very successfully. Even in the first markup, you can see Lamar Smith is in the first row, like watching the markup session of the Judiciary Committee.
Mm-hmm.
And it passed out of the Judiciary Committee, and then it was brought to the full House for everyone to vote on. And it was brought under something called suspension of the rules. So in the House, that is where you say, look, we're not going to like do the normal thing with a bill where we debate it and add amendments to it and have hearings about it. This is a special process that you can use in the House for non-controversial bills. So for the canonical example is renaming a post office. Congress doesn't want to spend 8 hours to rename a post office. And so you would put that on the suspension calendar. And so this bill was brought under suspension. 98.5% or 98+% of bills pass that are on suspension.
Because these are just like this is a way to just add efficiency to the system, right? Like what you're saying is you don't need to spend all this time. These things are kind of, yes, these are maybe more obvious. I don't know what the right word to use here is, but it's like, yeah, like you said, 98% plus pass that go this route. And so they're trying to basically kind of sneak this through in that way. Exactly.
And, all the way up until this date, UpCodes hadn't done anything in DC.
I was curious, like because this is a different ballgame than the lawsuit thing. This is something else, right? And so I was curious to find out kind of how you became aware of this, what your response was like. Was this something that you guys were really aware of, or is something that kind of even snuck up on you?
I mean, we were aware of it back from 2022, but we just said we can't do anything about it. We don't have money.
You don't have lobbyists.
Right. I mean, we don't have money to hire lobbyists. All our money is going to the litigation and to pay our team. And so, our small team, we've always had a very small team, by the way, compared to our size, because all the money has to go to the free law fight. And so we knew about the bill. We just said we can't do anything about it. And we didn't do anything in 2022 or the next year or the full half year after that. And they were just, meanwhile, kind of pushing the bill almost completely unopposed. And that's why it made so much progress. But then we heard it was coming to the suspension calendar, and we said, well, we don't have like resources to do something, but we have to do something. And so we sent out an email to our entire user base asking them, like, please contact your representative. We had one user who actually knew a representative, and he talked with them and was able to convince them that, like, this is not a non-controversial bill. You need to pay attention to this one. And so that was really helpful. And I mean, the bill failed on the suspension calendar. So that was really nice. But, it was closer than we would have liked. And I think there was just a lot of misunderstanding. We totally dropped the ball. I mean, we knew we were dropping the ball, but we couldn't really do much about it. And now, since that's happened, I think there's been a lot more awareness. We've actually finally hired a lobbying firm, so we do now have a presence in DC, or at least, we will make trips there. We don't have anyone actually living there. And we've gone to the offices, and it's just so much misinformation. They're all saying, but it just seemed like a good bill. It also seemed non-controversial because no one came and talked to us.
They didn't feel the opposition. So is that what you've done that personally? You go to the Hill and you have these conversations. You have to get on someone's schedule so that you get 5 minutes with them to talk about it.
Exactly. Yeah. So we'll go into the Hill. We'll meet with the staffers mostly. Occasionally, you'll actually talk to the member themselves. But mostly it's to the staffers who kind of tell the member how to vote because the member can't keep track of every single bill in every single area. And we will just we have a lot of handouts. So the first thing we give them is a printout of the 990s showing the financials of the publishers like ICC who are pushing the bill and saying that they're running out of business. And they're just like really surprised because but this is the whole motivation of the bill. And I think that it's been really, really helpful. We don't have nearly as much money as the publishers to spend on this. but our message is a lot easier. So, I mean, you go into an office and you say, look, here's what the bill actually does. I know it sounds like it enhances access to the law, and that's how it's named, but that is not what this bill is about. It is the opposite. And they've been very receptive, actually. So if you look at last Congress, there was 20 co-sponsors on the bill in the House. But you look at this Congress, and now there's only 5 of them. So the support for the bill has just kind of dropped out.
I see. Yeah. So it's interesting to see. But to your point earlier, like it really can just keep being brought up as long as they're willing to spend money lobbying.
Yes. And we expect the legislative fight to just continue forever and the litigation fight to just continue forever. That's kind of just our operating assumption.
So I think the last time your brother was on, you guys have a webpage that kind of makes it easy for people to contact their representatives and express their opinion. I mean, obviously, if they're representatives, they should understand the opinion of the people they're representing. And so that is kind of a call to action here too, right? I mean, this happened when you guys did this the last time and you sent out that email. I got that email and I went to your website and I clicked the 2 clicks or whatever it was to get what I needed from it to, you guys list out who my representatives are, right? Based on location, and then some language that I can choose to use or not. And when sending them a message, and it really does make a difference, right?
It does. Yeah. And thank you for doing that. Every message counts. I mean, I was in one office in the House and they were saying, yeah, we got a lot of messages from our people on this bill, which is unusual for a copyright bill. Now, if it's like, issues that people care about, immigration, law enforcement, taxes, it's kind of like issues that are more common, they will get a lot of messages. But they were saying we never get letters about copyright policy from our constituents. And we had 10, and that was a lot for them. They were surprised, and it got their attention. And it helped because I think the bill, it really kind of like, I think the publishers want to kind of keep a very low profile in the bill. And if they're getting a lot of letters about, this particular bill, they're going to say, all right, what is this bill? Why are people upset about it? And let me understand it better. Mm-hmm. And once they really understand that, this bill aims to allow private ownership of the law itself, they're like, that's insane. I mean, the number of times I've heard someone be like, this is a crazy bill. And how does this keep coming up?
So you guys call that the free law, kind of a principle or a fight. Can you just talk about, like, when it comes to, if you were to put yourself into the shoes of an AEC leader, principal, someone in a firm, like, what does that mean to them?
Yeah. So law is basically like anything that, has the force of government that is enforced upon a firm. Because there are, so talking about the codes, there's some codes that are best practices. These might be, ASTM has a bunch of codes that are not necessarily adopted into law, but you might choose to follow just to have a quality building. Those you will have to pay for because that's their product. You don't have to buy it. But when it comes to the actual law, that would be anything that is actually adopted by the government, carries the force of law. And so basically we'll post any kind of codes that people must follow. And that's how, it kind of gets broken down.
Got it. And I like the, it's easy to understand, right? Free law. It's laws, like you shouldn't have to pay to, my belief, my opinion, I'll just put it up, disclaimer up front, shouldn't have to pay to access those when I have to use them for my deliverables, when I have to use them to obtain a building permit for a client.
Right. You shouldn't have to pay to read them. You shouldn't have to pay to use them. You shouldn't have to pay to print them. If you want to quote a section from the law, you shouldn't have to pay for that either. So it really is, it needs to be free as in, they say free as in beer, so the price needs to be free, but free as in speech also. You need to be able to speak the words of the law without a license. You should never have to license the law from a private party.
I want to revisit your business model one more time here, because this is still a service that you provide for free. Like when you say free access, like this is something that you still do to this day. Talk about kind of the scale of that and what's available to the audience if they're not aware of this.
Yeah, so UpCodes, we've been doing this for over 10 years. We have over 6,000 codes on our site, all of them adopted into law. And it's split by jurisdictions. If you're, say you are in Austin, you could go on and you will find that the adopted codes for your jurisdiction and the particular year of your building.
Because every municipality has a different recipe for what codes they've adopted and are looking at for this current code cycle.
Right. And their own set of amendments. I mean, occasionally a jurisdiction will adopt the code without amendments. But typically there's amendments. And so we will integrate those natively. We'll also keep the code up to date with errata, with amendments by the government. So we have a 40-person full-time content team. And their whole job is to watch like dozens or hundreds of government websites for changes, any updates, errata, anything, and keep the codes up to date. And we change about over 50,000. I think it was 58,000 sections of code every month are updated on our site, and we host 11 million sections of code. Wow. And that is all free and unfettered. People can read it, they can copy paste it, they can print it, they can do whatever they want with the law. Now on the paid side, we do have, that'd be like our AI assistant. We also actually just this week launched AI plan review. So we actually have a native way to upload your plans and see the code errors, cite it back to the code. And so that's basically in the paid tier. But talking about the law is free on UpCodes and will always be free.
Yeah, and I think what's interesting is I keep coming back to this idea of innovation. There's a lot of room for things to happen with this, and there's this fight to keep it how it was, as if it deserves to continue to always be that way, and like lock it down and not enable innovative ideas to prove themselves in the market or not, right? Like that's a distinction that should be made, I think, is just like, well, you're putting your neck out there because you're having to fight all this stuff and continue to do the business. And there's absolutely no guarantee that this is going to work from an UpCodes perspective. You don't just deserve to exist because you want to have a company. Like you have to have paying customers. You have to provide value to them. And you're adding additional innovations on top of the building code here to make the life of an architect, a building professional, building environment professional, to actually do their job. And if they're willing to pay you for that, so be it, right? I think this is how it works. And so it's just kind of an interesting... this seems like a David and Goliath kind of a thing, but it also seems kind of like an incumbent and a startup kind of a thing. And there's no guarantee that the startup is going to win, right? But you do have kind of a different mindset when it comes to this. And it's interesting to see this play out.
I mean, especially in the early days, it was essentially a race for revenue and racing to get that revenue to pay off those legal bills. We call it like escape velocity. Like we needed to grow fast enough that we could keep up with the like mounting legal bills.
Yeah.
And
just stay ahead of it.
Yeah. I mean, it was like neck and neck for years.
Wow.
And we were barely able to kind of keep up to date with the legal bills. I mean, we've spent north of $10 million to date on litigation, and the publishers will have spent quite a bit more than that litigating against us. And it's just crazy, it would be nice if all this money could go to actually building things and making the world safer or, more innovative ways to comply. But unfortunately, just the cost of doing business is about half of our money has to constantly go to defending our right to post the law and build innovative tools on top of the law.
Yeah.
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 Unfortunately, it's all gone well. So, the courts have upheld it. And, we're still here today, still shipping new features. And so it's all worked out, but it is, maybe not the ideal way we would have gone about building the company if we had our choice.
Absolutely. Well, I'm going to put a link in the show notes to the website that you guys, the webpage that you have up, where people can get in contact and let their thoughts on the matter be heard. And then I think you guys post articles and such on LinkedIn every once in a while to kind of keep people in the loop on what's going on here. So I'll put a link to the UpCodes LinkedIn page as well, so that you can follow them and get those updates as they come out, as long as the algorithm is serving you well. There's no guarantees there. But is there anything else that people can do, or anywhere they can go to kind of just stay up to date with this battle or show their support for you?
I think those are the two, I'd say the big ones. Like LinkedIn is where we post the most. That's where we're kind of the most active. And then any updates big updates, we will post on the Pro Codes page that we have. And that's where the widget is where you can contact your reps that you were talking about.
Okay.
I'd say those are the main ways, actually.
Fantastic. Well, Garrett, thank you for the update. And I'm sorry it's continuing, but keep up fighting the good fight for us.
Well, thanks so much for having me. And I really appreciate the chance to kind of talk about the issue.
If you watched all the way to the end, thank you. That actually means a lot. I have two things I'd ask of you before you go. One, hit subscribe right now if you haven't already. It's totally free. It takes one click, and I'm really trying to get to 1,500 subscribers. We're not there yet, and every single one counts. If this show has been worth your time, that's the easiest thing you can do. Number two, if you want to go further, if you want to support independent coverage of this industry and get ad-free episodes of the podcast, plus my full Leadership Edge newsletter, head over to trxl.co and click the join button. The link is in the show notes. $12 a month, and you'll be one of the people who actually makes this possible. All right, that's a wrap. Subscribe, share it with someone who would get it, and I'll see you in the next one.